Right, good evening, ladies and gentlemen. Today is the 14th of April 2025, and it's 10:15 in the evening. And my name is Benjamin Kinichi, the chairperson of Zimbabwe Immigration Federation. And today I'm coming to you, all ZEP holders or Zimbabwe Exemption Permit holders, because of the developments that are unfolding. And I mean, in summary, the Minister of the Department of Home Affairs has appealed against our ZIF case. We had a case that went into court on the 13th of April 2023, and of the judgment or the court order of which was given by the Gauteng High Court on the 28th of June 2023. So, so the Minister of the Department of Home Affairs, together with the Director General of the Department of Home Affairs, have appealed against that case. And that appeal will be, they have appealed at the Supreme Court of Appeal, and that appeal is going to be heard on the 13th of May 2025, which is about a month from now. So it's very important. We felt that it was very important that we come to all the ZEP holders today and to take them through what the appeal means to them, and also what it is about, so that you get the knowledge. We have promised that we will make sure that we give you the knowledge that is necessary for you to make informed decision on our platforms. So you would ask yourself, so we had a meeting yesterday with the ZIF contributors, and we were the owners or of this organization, and we had a meeting with them. And one of the burning questions in that meeting was, why would the minister take ZIF or appeal against the ZIF case when he has offered to do the judicial review process according to the court order of the Helen Suzman Foundation? We need to go into the fundamental differences between the two cases, which is Part A of the of ZIF and also the Helen Suzman Foundation case. But what we see in the appeal itself, when we go through the appeal document, it's 40 pages long. And when you go through the appeal document, you find that the appeal is not necessarily about the interim relief that was granted in the court order of the 28th of June 2023, rather, but it is mostly about blocking Part B of the ZIF case from going into court. So I say that because Part B is mentioned more than Part A of the case, more than the interim relief in the Part A case. So to give context, the ZIF case was divided into two parts, and it is one case. So just get that correctly. There's been people that have been saying they want to know the court case or the case number for Part A and case number for Part B. Those two Part A and Part B are only two parts of one case. So the case number remains the same because it's just the same case. It's the same case that was divided into two parts. I will explain why dividing it into two parts, and as we go. But it's very important that we understand that part. And also it's very important, before I go into explaining the fundamental differences between the two cases, the Helen Suzman Foundation case and the ZIF case. So it's very important that I explain also that there is three organizations that went into to challenge the decision of the then Department of Home Affairs and Minister to terminate the ZEP permits. So the first one was the Helen Suzman Foundation. The second one was Zimbabwe Immigration Federation, ZIF, which is us. And the third one was ZEPA. ZEPA was the one that was represented by Advocate Simba Chitando. So of the three cases that were contesting the termination of the ZEP permits, two of those cases were successful. The other one was unsuccessful. The one that was unsuccessful is the ZEP case that was represented by Advocate Simbachitando. So we're not going to be going into that case at this stage because it was unsuccessful. But then we're going to look into the 2 court orders that were given by the court, by the Gauteng High Court on the 28th of June 2023. So if you look at the appeal is 40 pages long, and it talks more. I mean, 33 times it mentions the word Part B. And while it's mentioning the word Part B, it's looking at the fact that, according to them, Part B is now moot because of the word moot there means that it has been overtaken. In layman terms, it has been overtaken by events, which means that it's not prosecutable. So that's just in layman terms, in terms that we will understand. So what they're saying here is, in their court papers, is that Part B is moot, so it should not be heard. It doesn't have any chances of success. But I'll come back to that. I'll come back to that at a later stage. But based on the nature of proceedings, so the Helen Suzman Foundation's case was a final review application, and it was challenging the legality of the termination of the ZEP program. So in that, the court ruled on the merits and declared the minister's decision unconstitutional and invalid. So in summary, when you look at the Helen Suzman Foundation case, that's what you see. But when you also look at the ZIF judgment, the ZIF judgment was an interim interdict application, which was called Part A. And that interdict was seeking for temporary relief to prevent, the deportations and all those things that were happening at the time. If you remember very well, there was a time when the then Minister of the Department of Home Affairs had threatened on national TV that ZEP holders and their children were going to be plugged out from school, they were going to be plugged out from their places of employment, they were going to be plugged out from wherever they were having their livelihoods. If they had not migrated within 12 months to new visa regimes. And while at the same time, there were stringent measures put in place to ensure that the ZEP holders will not be able to migrate to the mainstream visas. And we're talking about this before some of the exemptions were also given in the terms of in the form of waivers. But at the time, there was need at the time to apply for interim interdict. So we asked for Part A. In our Part A, we asked for interim relief pending the outcome of Part B. So in our case, the court did not decide, what the substantive legality would be, but rather it preserved the status quo at the time to say that ZEP holders should be given the rights or the exemptions that have been given to ZEP holders must remain until the outcome of Part B. So that is also the difference between the 2 cases when you look at the Helen Suzman Foundation case and the ZIF case. In terms of the relief that was granted, so the relief that was granted for the Helen Suzman Foundation set aside the minister's decision to terminate ZEPs. So listen very carefully and understand the relief that was granted, because the differences between the relief that was granted to ZIF and the relief that was granted to the Helen Suzman Foundation. So the relief that was granted to the Helen Suzman Foundation, it set aside the minister's decision to terminate the ZEPs, and also it ordered a 12-month grace period, which ended in June 2024, for ZEP holders to retain protections, which means that there was no deportations to be happening, there was no arrest to happen, while the minister considers the decision that was made to terminate the ZEP permits, because it fell in line with what the Helen Suzman Foundation was asking for. And then for the ZIF, the relief that was granted was an interim interdict that was also barring deportations and arrest of ZEP holders until the main review of Part B is decided. So there was no substantive relief for ZIF, but it was purely some temporal safeguards, to ensure that the ZEP holders do not get deported, they do not get arrested, they do not get kicked out from work, for example, because for reason that they are ZEP holders. So those are the fundamental differences that we're starting with here in terms of the relief that was granted between the two. And then you look at the legal grounds also in comparison. So the ZIF, the Helen Suzman Foundation case focused mostly on procedural fairness. So it was looking at the procedure that was used by the minister to terminate the ZEP holders. It looked at the failure of the Minister of the Department of Home Affairs to consult with ZEP holders before the exemptions were terminated. And it also looked slightly at constitutional violations, which is the violation of the right to dignity, the violation of the children's rights, the violation of the right to equality, and so on and so forth. And also, the court then found the decision of the minister based on the focus of the Helen Suzman Foundation focus. The Gauteng High Court now found the decision of the minister to be irrational, to be procedurally unfair, and also that it had an unjustified limitation of the rights, under the Paja and the Constitution, meaning the decision of the minister here. And for the ZIF case, the ZIF case mainly addressed the requirements for an interim interdict. And we also argued that the minister acted in what's called in legal terms outra vires. In other words, we're saying that the minister used Section 31 2B2 of the Immigration Act. If you look at the directive, I think it was Directive 10 of 2021, that the minister used to terminate the ZEPs, the minister said that he was using that section of the Immigration Act based on the powers that are granted to him by that section of the Act. But our argument was, first of all, that there was a prima facie right that was established, and also that the minister acted in outra vires. What that means is that he did not have the power, that the act that he is quoting did not give him the power to terminate the ZEP permits. And we also focused on irreparable harm, and by that we meant that the decision of the minister would cause irreparable harm to families, and some families would be separated, and there would be loss to livelihoods. And also that the termination of the abrupt termination of the ZEP permits would impact also the rights of the ZEP holders. We looked at the right to life, we looked at the children's rights, we looked at the right to equality, we looked at the right also according to Section 33 of the Bill of Rights, the right to judicial review. So all those, we said that the termination was violating those. And also we also argued that the balance of convenience was favoring ZEP holders in all those arguments that I have mentioned here. And in terms of the parties that were involved in the scope of the cases, in the Helen Suzman Foundation, the case was brought in by two NGOs. The one is the Helen Suzman Foundation, and the other one is COMSA, which brought these cases representing public interest and ZEP holders' rights. And there was also a counter application, which is the fourth case. I spoke about three cases, but there was one that was a counter application, which was by the All Truck Drivers Forum which was dismissed for undue delay at the time. But when you're looking at also the parties and the scope, the ZIF case was filed by Vindren Magadzire. Vindren Magadzire is a director in Zimbabwe Immigration Federation, or ZIF. And so it was Vindren Magadzire and the Zimbabwe Immigration Federation. And our case narrowly focused on urgent interim relief to prevent harm post-June 2023, which is also why we are sitting here now, because the court order that the order that we were seeking was to protect ZEP holders post-June 2023. So it's very important that we understand the protections that we have and where those protections are coming from. Not to downplay the Helen Suzman Foundation case, because they have pulled through and they also assisted, especially with the judicial review process that the minister is committed to do. So we worked also hand in hand with the Helen Suzman Foundation during that time when we were also going to to attend our court case, and also we exchanged notes a lot. One of our arguments would have been, one of our strongest arguments would have been asking for judicial review, but we didn't ask for that because of the collaboration that we had with the Helen Suzman Foundation, because we realized that also that was also one of the points that they were going to argue. So I'm just putting it out there so that you understand how we worked together during that time. So looking now at the outcome. So based on the outcome of the two cases, the outcome of the ZEP, the outcome of the two cases and their importance to the ZEP holders. So for the Helen Suzman Foundation case, very important that you listen very carefully and understand this. The Helen Suzman Foundation brought in a complete case. Their case did not have Part A and Part B like the ZIF case. What that means is that the Helen Suzman Foundation got their final victory in the outcome or in the orders that were given by the court. And that final victory meant the termination of the decision of the minister to terminate the ZEP holders. So that decision was considered to be invalid. And they were given a 12-month reprieve pending the conducting of a judicial review that by the minister, and the minister was also ordered to conduct a procedurally fair review, which means the minister had to do a fair review process. But that's for the Helen Suzman Foundation case. But what outcome was the ZIF case? The ZIF case got a temporary protection. So it's very important to understand this. For the Helen Suzman Foundation case, they got what they got is it was their final victory. After that victory, they were not going anywhere anymore. If the Helen Suzman Foundation is going to be involved in the ZEP cases, they will have to launch a new case. At this stage, the case that they launched and what they asked for has been granted. And also the minister has offered or committed to conduct a procedurally fair process of judicial review, where he is going to review the decision by the former minister to terminate the ZEP permits. But in terms of ZIF was granted a temporary relief, and the substantive challenge to the ZEP crisis was referred or deferred by the courts to Part B of the case. So in Part A of the case, temporary protections were given. Like I said earlier, that our case narrowly focused on urgent relief to prevent harm post-June 2023. So we got that, and also we were given 12 months to launch our case. So we from June from the 28th of June 2023, we were given up to the 27th of June 2024, of which we went in and filed our notice of motion, which is what is bringing us where we are now, right? And also the other section that we're going to look at in terms of the differences between the two cases is the judicial reasoning or the legal reasoning between the two cases. So the reasoning in the Helen Suzman Foundation case was a detailed analysis of administrative law, which is the Paja Act, and the constitutional rights, and emphasizing the minister's failure to consider the impact of the termination of the ZEPs on ZEP holders. And it also highlighted the separation of powers, but found the decision indefensible. So in other words, what the Helen Suzman Foundation said, what the Helen Suzman Foundation case said was, we are not, they said in not necessarily quoting, but just paraphrasing what they said. They said that they were not prescribing a decision for the minister, but they were saying that the minister, they acknowledge the separation of powers between the judiciary and the executive, but also they were saying that the minister's decision was indefensible, and also they were saying they were not prescribing a decision for the minister, but they were saying at least the minister should follow a procedurally fair process and come to whatever decision the minister comes to, whether the minister decides then to terminate the ZEP holders after following the judicial review process, or after following a fair process, or decide that they're going to extend, or decide that they're going to make permanent the exemptions. It's up to the minister, but they were saying that the process that was followed was procedurally unfair. Right, that's the Helen Suzman Foundation in terms of their judicial reasoning or their legal reasoning. The ZIF, which is our reasoning, was that we were our priority in Part A of our case was that we were prioritizing agency and practical consequences. I mentioned that we argued about family disruption. We argued also about the mass deportation of people that are legally in the country. The country has a huge problem with illegal immigration, but then the termination of the ZEP was adding to that problem. It's adding to the problem of illegal immigration. So we were saying that these people are already legal, why make them illegal? And also we avoided getting into deep engagements with constitutional arguments in our Part A, because we reserved that for Part B. So our case, because it was divided into two parts, the one had to focus mainly on the agency that was there at the time. And then Part B would then now focus on the constitutional arguments. And those arguments at this stage, we are the only ones that know what we're going to argue, which comes to what our arguments will be when we go to the Supreme Court of Appeal, because nobody knows what is in Part B. But when you look at the court documents that have been filed by the minister, they say that the Part B of the case has been rendered moot. At the same time, there is no knowledge of what Part B contains. So that is what our argument is going to be, and also other parts of the arguments, other parts also that we're going to argue, and we're also going to argue especially that our two cases are completely different, right? And then so in summary, looking at the two cases, the Helen Suzman Foundation judgment and also the judgment in this ZIF case, The Helen Suzman Foundation got a final and comprehensive ruling, which invalidated the termination of the ZEPs and declared them unlawful and procedurally flawed and unfair, and therefore invalid. But the ZIF judgment was a temporary and procedural order that prevented immediate harm to the ZEP holders, and also left the substantive challenges to the ZEP crisis to Part B of the case, which is now where we are going now, where we have filed our notice of motion and our notice of motion, and also waiting also to go into the Supreme Court of Appeal to defend also the ruling of the Gauteng High Court of the 28th of June 2023. So the similarities between the two cases is that both the two judgments, they underscore the systemic flaws in the termination of the ZEP, or the process that was followed to terminate the ZEP permits. But both of them, although both of them operate, of course, in different stages of litigation. So Part A operated in one stage of one part of two stages of litigation, and then the Helen Suzman Foundation case only had one stage, and whatever relief that they got or whatever order that they got from the court was the final one. So we're going now to the end of this presentation, and now what next? What next? So what is next is that our lawyers, which is Mabuza attorneys and Advocate Tembekan Kaitobi and his team, on the 13th of May 2025, they will be going to the Supreme Court of Appeal in Bloemfontein to defend Part B. Not necessarily defending Part B, but they're going to be defending against the appeal, that the minister's appeal. And we know that from the documents that have been submitted by the minister, that what the biggest concern is Part B of the case. And the reason why we say that is because if you look at the relief that was granted to ZEP holders post June 2023, it has been superseded by a lot of directives that have been issued by the minister. The minister himself has issued directives extending those exemptions, which means that the relief that was sought for in Part A, the temporary relief, has been superseded by those directives. So if it has been superseded, why would the minister then go to court to challenge the court order of the 28th of June 2023? It can only be because of Part B. And also when you look at the contents of the document itself that has been filed, it's for 33 times it speaks of Part B. It speaks of how Part B will not have a chance, how Part B is now moot. So so we basically saying that the minister is challenging the launching of Part B of the ZIF case. So it's fair that we can come to that conclusion. So our goal then both in Part B and also in this Supreme Court of Appeal, our goal is simple. Our goal is to prove that ZEP holders deserve permanent relief. So it doesn't matter what the permanent relief comes, which form the permanent relief comes in. We're not here to prescribe for the minister what the relief looks like. It's up to the minister. But so some would ask to say, why then are you defending it when there is a judicial review that the minister is committed to, but that's the Helen Suzman Foundation case. The Helen Suzman Foundation case was asking for judicial review. The minister is committed to that, but the minister is not committed to anything in our case because Part B of the case is not heard yet. So it's just fair. It's you can't really blame the minister for that. The minister would also want the court also to give direction on where things should go in terms of Part B. I've explained the risks that the minister sit with. For example, that the judicial review will go ahead, and then at the end of the judicial review, then Part B comes and supersedes also the judicial review process, because what Part B would be asking for and what the Helen Suzman Foundation would be asking for is completely different. So it's very important that that the minister also does go and seek that review, go and also seek the court's opinion on those cases. So it's very important. If it was us, also we would still go to the Supreme Court of Appeal and also get the Supreme Court of Appeal to also give a ruling or to give them their thoughts based on those outcomes we are discussing here. So as a ZEP holder, why should you care? Why should you care about this or Supreme Court of Appeal if you're a ZEP holder? So it's very important to note, I think I've explained this, that the Helen Suzman Foundation case, their prayers in their case was to say to the minister, you need to redo your decision by doing consultations with the ZEP holders, and then come up with any decision that you come up with, whether you come up with the decision to say, we have done the review process, but after the review process, we still feel that the ZEP permit should be terminated. So that decision has been left by the Helen Suzman Foundation in their prayers to the minister to make that decision. But consultations, they said, let the process be fair. So the ZIF case is focusing on the rights that have been acquired by ZEP holders for the past 15 years. The argument is that it's not good cause based on Section 31 2B2 of the Immigration Act, which says that on good cause, the minister can terminate any, can withdraw any exemptions that have been granted. So it begins there with on good cause. So our argument is that it's not good cause that if a person has stayed in a country for 15 years, has had children that are going to school, children that have never been to any other country besides South Africa, and then you terminate that exemption and you uproot that child and you plant that child in a different environment. What we're saying is that the chances of that child to succeed are very low. The life of that child is completely disturbed. We are also looking at the right to equality. We're also looking at not mostly the right to judicial review, because that is what the Helen Suzman Foundation was looking into. But we were looking into the idea of mass deportations, the idea of uprooting people after 15 years and expecting that their life would be the same on the other side. So so that's basically what we're looking at, and that's why we're asking for permanent relief, to say the relief that not necessarily there's a difference between permanent residence and permanent relief. Those two are different. We are saying that what we're asking for is that the rights that have been acquired based on the Bill of Rights are permanent. Therefore, they need a permanent relief. So it would now be up to the minister to say what kind of permanent relief is it that should be given to ZEP holders based on the contribution to the economy, for example, and so many other factors that will be presented in the court at the Supreme Court of Appeal. So So it's very important for you as a ZEP holder, first of all, to be part of the ZIF, part of the ZIF team. And it's very important also for you as a ZEP holder to work together, for ZEP holders to work together to ensure that the SCA does not block Part B of the ZIF case. Because once that Part B is blocked, what that means is that every ZEP holder loses the chance to a permanent relief based on the based on the rights that have been acquired by ZEP holders. So I see that it's now about 40 minutes of this presentation, but then there was no other way of shortening it up. So I urge you to just spend your 40 minutes, listen to this presentation. And if you're a ZEP holder, there's only one organization that is registered, that is compliant with the laws of South Africa, that was registered solely to represent ZEP holders. There's no other organization. So ZIF is your organization if you're a ZEP holder. So if you want to join ZIF, we'll leave a link in the chat where you can request to join some of our platforms. You will be requested also. You will be for you to be admitted into our platforms. You will have to verify yourself, of course, for obvious reasons. But the verification is not that tough. So you should be able to verify yourself that you're a ZEP holder, and then you will then join our platforms, and then we can have the discussions about all these cases that are going on, and also how we can help you in the interim. How do we help ZEP holders for things like your kids being denied to go into school, things like being denied public medical services, and so on and so forth. So if we stick together and we work together, then we should be able to protect each other in that during those times and in those kind of circumstances and situations. But I've spoken enough. I've spoken too much. It's 42 minutes now. And but thank you very much for everyone for listening to us, especially ZEP holders. And if you have any questions, just join us. We will be able to answer those questions, and we'll be able to explain some of the things and the events that are happening. We've got our Facebook page. We'll also leave a link to our Facebook page in the chat, so that if you also on Facebook, you can join us, and then we can collaborate together, work together, and have these discussions together. Thank you very much for joining us. If you're here and you're a ZEP holder, please like our page, share our page, and also click on the subscribe button so that you can be subscribed. And you can also click on the notification bell so that when we get new content, you'll be the first to get it. We're happy to be talking to you and giving you all this information. I understand that we kind of sometimes overload the information, but sometimes there's no other way. Explaining a 40-page document in a very short space time becomes very difficult. But thank you very much for spending time and listening to the to this presentation. We'll talk again, and we'll be giving you quite a number of videos between now and when we have filed also our responding affidavits and our responding documents to this SCA challenge. So we'll also be coming here and give you updates. You know, I think at that time it's going to be shorter videos. But thank you very much for being with us. Thank you very much for listening to our videos. We'll be in touch. We'll be talking again soon. God bless you. Stay blessed. Pray a lot, and God guide you. Thank you very much, and good night.